You not trust them before. Go ahead. Really, court hearings. All right.
All right, welcome back. Proceedings of the Sixth District Court of Appeal. The next case will be Mannheim Remarketing Inc. versus Patriot Insurance, Christopher Banker. We have Mr. Maine and you are Mr. Steins. Okay. All right, you'll each have 20 minutes for your arguments, and you can. You want to reserve 5 minutes? Yes. All right. Oh, hang on, let me reset this. Okay, recognize it.
Good morning, your honors. May it please the court. I'd like to start this morning by borrowing a phrase from the Supreme Court so that I can emphasize the point to this panel. That if Patriot Insurance and its principal, Christopher Banker, are allowed to escape liability in this matter by essentially relying on a prior settlement that was entered into by others who had no intention whatsoever of releasing Patriot from their liability, in fact, just the opposite, that such an outcome would be the epitome of manifest injustice. And that's the phrase that's the Supreme Court used in the Toomey opinion. It's not just my own hyperbolic spin.
Counsel, we've all read Toomey and we're familiar with it. And I understand your argument on intent. I do. But what I'm struggling with is the order of events in this case. And what I need is help understanding why this order doesn't matter. So in here, it's my understanding that we have a consent judgment that's entered into before there's it's entered into after there's an assignment. Can a consent judgment be effective if it's entered after the assignment? And do you have any cases to that effect?
I'm unaware of any case law that's directly on point on that issue, Your Honor, but I would submit that a consent judgment is effective. It's an obligation, a debt that Julie's Innovation Services owes, and the mere fact that it was entered after the assignment I would respectfully submit is not pertinent to whether or not it's a debt that Julie's owes.
But it's a debt, it's an obligation, it's entered into after the fact. There's already been an agreement to defend and indemnify. And so Julie's, or JIS as it's called in the other brief, never takes a hit. They never have that damage element that accrues to them. It only accrues to Mannheim. Why does that not matter?
Well, Your Honor, again, that's really the intent of the reason the parties entered into the agreement. I mean, it's important to understand, critically important to understand that the allegations in the underlying Warlick lawsuit were the same directed to Julie's as they were to Mannheim. Vicarious liability for the negligence of their driver, Vernon Hoyap. So again, I mean, we can look at it the other way. If there was no agreement and Julie's had remained in as a defendant in the Warlick lawsuit, their liability would have been exactly the same as Mannheim's, which ultimately, after 5 years of protracted litigation, resulted in a $1.8 million judgment.
Let's take Mannheim out of it. At what point does Julie's have a viable cause of action against Patriot? If there's no Mannheim, at what point does Julie's have a cause of action?
I would argue that the cause of action would accrue the day that Julie's bound the Covington policy, the liability policy that the Patriot recommended, that had an auto exclusion that excluded liability, any claim related to an automobile. And so that with basically going bare, they went into the litigation, the Warlick litigation, with no liability coverage. And so again, but for the fact that Mannheim and Julie's entered into the settlement, their liability would have been the same. So I think you're right to the extent that the last element of the cause of action accruing would be when they had damage. And so you can look at it one of two ways, actually. You can look at it as to the damage relating to the Warlick lawsuit, but you can't also overlook the fact that they were also sued by Mannheim in the coverage litigation for indemnification, because they had indemnification obligations under the staffing agreement. And so again, without any liability coverage for those indemnity claims, they sustained a $1.8 million judgment in the coverage lawsuit. So to your point, the damage, I guess you could say, was when the consent judgment was entered in the first consent judgment was entered in, I believe, November of 2017.
That's right. Counsel, do you have any cases, and maybe it's a fundamental area of law, that you need to talk about, but do you have any cases where you can combine the elements to complete a cause of action? So for instance, the duty is owed to JIS, right? Patriot owes JIS a duty, no doubt. There's an allegation, and maybe it can be sustained below if this case continues, that Patriot breached that duty. But if we find that Mannheim is the only entity to have suffered damage, under what theory do they get to combine to create one completed cause of action against Patriot?
Well, Your Honor, I would submit that when you suggest that Mannheim is the only party to sustain damage, that would again overlook in its entirety the $1.8 million judgment that currently is entered again. It remains unsatisfied against Julie's.
But then we get back to the order problem, right? If we don't solve the order problem, which is at the time that they sustained that damage, they had already executed an assignment and release, and they had already been indemnified.
Right, which I would argue is the exact scenario of Toomey. In other words, that Toomey contemplated this release of a party accompanied with an assignment at the same time that would allow via the assignment for the assignee to then pursue claims against the insurance broker for their breach of fiduciary duties.
Why should I discount the fact that Toomey is a simultaneous release and assignment versus what I have here, which is, I believe, a 2-year. I have an agreement to indemnify and defend a company 2 years before they sustain any damage, which will never hit them.
Well, that's an important point, Your Honor, because again, if you look at the facts in Toomey, you have assignment and release, and then the actual assignment document wasn't executed until August, I believe, 5 months after the parties entered into the agreement. So again, there is a stagger there that is indicated within the factual summary.
Counsel, you're right. And I read that a few times because, but it went on to say, or it began with, the litigation resulted in a judgment. So it wasn't just the settlement agreement that they go on to talk about having the delay. I thought there was a judgment that predated that in Toomey.
And actually, Your Honor, the more I think about it, to your earlier point, you could make the argument, I will make the argument that the cause of action accrued in terms of Mannheim's damages against Julie as a result of Patriot's failure to procure appropriate liability coverage, the moment that they began incurring defense costs, having to defend the Warlick litigation. Because again, Mannheim's position at that point in time was, you breached the staffing agreement, Julie's. You owe us a duty to, you owe us contractual indemnity under Section 10 of the staffing agreement. So again, I would make the argument that those damages accrued the day that Mannheim began incurring defense costs.
So then the opinion would read that once you have a penny, right, a peppercorn or whatever, once you have some small scintilla of damage, that your cause of action accrues, it's capable of assignment, and you can tack on later damages.
I would argue that, Your Honor. And
is there no limited time frame? You can just continue to accrue damages down the road?
no, well, the time frame as it relates to our set of facts is that again, without any liability coverage, Mannheim was left to carry the full carry the entirety of the water in the Warlick litigation. Mannheim had to defend that litigation for over 5 years again, and ultimately was able to negotiate a successful outcome of that litigation. So from start to finish, the cause of action again, and then the consent judgment basically reducing to a dollar amount the damages, the full amount of the damages that Mannheim incurred was entered into, I believe, less than a month after the settlement was reached in the Warlick case.
If you prevail here on this appeal and you're able to pursue, Mannheim is able to pursue its claim against Patriot, Patriot's not precluded below them from saying, I don't know why those guys paid $2 million. This person had a, broken thing. I'm hypothetically had much less severe injuries than $1.8 million worth. And even if there is some showing of negligence on the part of the Patriot for not procuring the proper coverage, we're still not on the hook for the $2 million. Do they have the ability to do that?
I would argue that, Your Honor, that they do not, again, to the extent that there is a judgment that's been entered against Patriot's client to the tune of 1 point.
That would seem more problematic, at least in my mind, to your position here, because they then are not involved. Patriot's never involved in the ability to mitigate its potential exposure because they are now basically handed this $2 million bill.
I understand the court's concern, Your Honor, but I would submit that, again, that those circumstances are no different than the facts in Toomey, where it basically resulted in a $1.8 million judgment. And that the broker, that was the element of damage as it related to the subsequent breach of fiduciary duty and negligent procurement of insurance claims, that the assignee would bring it against the insurance broker and the Wachovia case, the Toomey case. And so again, returning to the two principal reasons why we believe that the trial court erred in entering summary judgment in favor of Patriot, is the flawed notion that simply because there was no, Julie's did not incur any sort of pecuniary loss in the Warlick lawsuit, that somehow that means there's no damages in this case. And as I laid out in both the initial brief and the reply brief, that's a premise that's flawed for two principal reasons. Number one, it overlooks entirely that the only reason that Julie's didn't incur any damage in the Warlick lawsuit was because of its settlement with Mannheim that resulted in the assignment. Again, the very set of circumstances that are laid out in the Toomey case that the Supreme Court said is a viable way for an insurance client to assign its rights against its insurance broker or insurance agent if there's been a breach of fiduciary duty. So that's number one. And then number two, it also overlooks the fact that without question, Julie's has incurred a pecuniary loss as a result of the Warlick incident. And again, it's important to point out that the indemnity claims that were litigated in the coverage lawsuit resulted in, again, alleging that Julie's breached its indemnity obligations to Mannheim under the staffing agreement, that those cross claims resulted in what ultimately turned out to be the consent judgment that's at issue on this appeal for $1.8 million.
Let me ask this. In the last part of the judge's order incorporating the final judgment, he writes, she writes, excuse me, apologize. There's no record evidence that Julie's attempted to minimize liability in the decade. The record evidence supports a finding that the consent judgment and assignment were the product of collusion and therefore unenforceable against Patriot. I get maybe that's somewhat going back to my earlier comments. So this judge is finding on using the current summary judgment standard that there's nothing in the record that indicates that basically that this is a good faith settlement. I mean, would you read it that way?
I'm glad you raised that, Your Honor, because that's really the second prong of the appeal. And I wanted to bring to the panel's attention that our situation is a little bit different than a typical Koblenz agreement or the Style or Sidman case that Patriot references in their answer brief. It's important to understand that the damages that are being sought in this action are pecuniary losses that have actually and already been incurred. Unlike the typical Koblenz agreement, these are not, it's not a fictitious number. It's not some theoretical number.
Yeah, counsel, I agree that you are different for a lot of reasons. One of the most interesting is there's another party here, right? We don't have the three entities. We actually have four. But the big picture argument being made, and if we were to agree with you, we'd have to write on this, is what is the focus? Your colleague says our focus should not be on the amount that was paid or the judgment that was incurred in the tort litigation. It should be on the coverage action. He says that our focus should be on the insured, which typically makes sense. But here, should our focus be on the insured or should it be on the assignee? What action, whose actions are we looking at? Are we taking a big picture or a small picture? Are we looking at just the negotiations, the years of protracted litigation, what timeline, whose actions, and what lawsuit?
I would submit, Your Honor, that as it relates to any focus on the insured, I mean, those were the issues that were being litigated in the deck action that Covington filed, arguing that there was no coverage for very good reasons. I mean, their policy had a standard auto exclusion. again, and that was really the impetus for the settlement that was reached. All parties realized, again, in the underlying coverage litigation, that it didn't make a lot of sense to spend a lot of time litigating those issues, because it was pretty clear that the Warlick incident arose out of the use of an automobile, and the Covington policy had a standard auto exclusion. So I would submit that that aspect of what happened was it was certainly alleged and litigated, and ultimately resulted in the settlement that included the assignment.
So Covington was going to win the deck action.
I mean,
It seems clear they were. going to win
it
the
seems, I mean, the Warlick incident, without question, undisputed, arose out of the use of an automobile. And the Covington policy included a standard auto exclusion.
So if the judge here said, basically the judge's ruling as a matter of law that this consent judgment was the product of collusion, that based upon the facts before the judge and the context of the summary judgment hearing, she made a conclusion that as a matter of law, no quote jury the summary judgment standard was appropriate. Where do you suggest? I'm sorry. Where do you suggest that how does the evidence support that finding?
Well, Your Honor, one of the last argument that was raised in the initial brief was that those are matters that we would respectfully submit our factual issues for a jury's determination. But just to go to the point again, the undisputed facts show that it was an actual pecuniary loss, not a hypothetical or theoretical dollar amount.
When you say actual, so the medical expenses in excess of $1.8 million?
No, Your Honor, that Mannheim actually had to pay that, Mannheim incurred that financial loss.
Well, because they agreed to it. But the argument is if there's one thing, look, the guy has $2 million in medical bills already because he's paralyzed or whatever.
Right.
Then there's an economic loss. It's hard to say that's collusion when they're looking at down the barrel of the litigation.
Right. I understand the court's point. The medical damages were in the neighborhood of $500,000, and it was a clear liability action. We had Mannheim had been receiving settlement offers north of $3 million. So the fact that Mannheim was able to get the matter settled for 1.6, again, money that it had to pay, we would argue was not a collusive.
Counsel, is that on the record, the economic damages?
The economic damages that Warlick sustained, I don't believe are something that are part of the record in this case.
You'll reserve the rest of your time.
Thank you, Your Honor.
Okay, you got about it. I'll give you 3 to 4 minutes. Recognize counsel.
Thank you, Your Honors. If it may please the court. Your Honors, I want to highlight 2 important points before I get into my arguments. The first point, I think the panel realizes, even though Mannheim is sitting there, these are not Mannheim's claims. Mannheim is suing Patriot as an assignee of Julie's Innovation Services. This is Julie's claims, JIS. Therefore, Mannheim's losses, what they paid, their complaints, their gripes, are totally irrelevant to these proceedings. They are stepping into the shoes of JIS to sue Patriot. My second point, this is a case within a case. This is a insurance coverage action within a professional malpractice action. Why? Because the measure of damages is what the insurance carrier would have paid if the insurance policy was properly procured. The agency steps into the shoes of the insurance carrier to pay covered claims and only covered claims. I cited a case, the Capel versus Gamble case, which is 733rd, Southern 2nd, 534, First DCA. In that case, the proposition was, or the holding was, just because you have a loss does not mean it's covered. We are talking about covered claims. That is why I put Mannheim on point. Mannheim, what was supposed to be procured? What was a policy that was supposed to be procured, and what would it cover? When I asked Julie's, the corporate rep for GIS, what should have been procured? She didn't know. I asked their expert, what should have been procured? An automobile policy, specifically a hired non-owned automobile policy, but some form of automobile policy. Okay, What would that have covered? It would have covered the automobile lawsuit, the Warlick litigation. There's no record evidence, Your Honors, that the automobile hired non-owned coverage would step in to cover a consent judgment. It's not there. Now recall, this consent judgment that Mannheim is relying on, that was for a breach of contract action.
Well, let me make sure I'm following this, what you're saying here.
Sure.
You're speaking well, but let me make sure I'm clear. So Mannheim hires Julie's, and Julie's is going to be providing drivers of the Mannheim vehicles.
Yes, Your
So
Honor.
Mannheim has an agreement with Julie saying, okay, we understand that you're going to be hiring these people to drive. Occasionally, there might be a motor vehicle accident arising out of this about what your driver, whether it's an employee or an independent contractor, but what your Julie's person is doing driving the car. And we want to make sure that we are protected and there's coverage for if that happens, because we are going to get sued by Mannheim because we're the owner of the vehicle. No different than if my son's driving my car and hit somebody. I mean, well, that's my son. They're going to sue me too. So Mannheim wants that coverage. Julie's goes to Patriot, says, I need to have this kind of coverage. And Patriot says, here, go, Covington is going to give you the coverage. And so Patriot, says, and so Julie's gets the coverage from Covington. Covington is then tendered the defense of this case, the Warlick case. And Covington, as far as I can see, rightly says, hey, that's not covered under the policy that you guys bought from us. And so they bring a deck action, and everybody's joined in. So then it turns out Mannheim, everybody's sitting together saying, yeah, this isn't going to be covered. Mannheim is saying, we're looking down the barrel that we're going to be liable as the owner of this vehicle. So we're going to make we think that Patriot messed up here in getting the wrong coverage. Julie's, we'll take you out of the case. We'll cover anything that you would be exposed to having to pay because of your employee doing this. And you just assign the cost of action that you would have against Patriot for not getting the correct insurance. And when we get past the litigation with Warlick, we'll come after Patriot to see if we can recoup some of our money. Julius says, good deal, we're done. We're not bleeding any more money out of this litigation. Good luck with everything. And so now Mannheim settles the case and comes back and says, okay, Patriot, somebody owes us $2 million for what you should have acquired the correct coverage, and we wouldn't be paying this. And we'd like to recover from you. Why doesn't that make absolute sense to other people besides me?
Because of coverage, Your Honor, because this is a negligent procurement case. You're talking about liability and the standard of care here. But remember, the insurance agent steps into the shoes of the carrier and pays what would have been covered. You're talking about debt action. Mannheim wants to focus on the fact that the Covington said there's an auto exclusion. However, they also said, pursuant to the agreement between Mannheim and Julie's, Mannheim said they would have a garage policy that would cover these types of claims. That was one of the allegations in deck action. The other allegation they made was Mannheim's insurance carrier is primary and they should cover these types of claims. So yes, Covington had several arguments as to why there shouldn't be coverage. It wasn't only the auto exclusion. There was a reason why the Covington policy was designed the way it was designed. It was because Mannheim said, we will pay for any losses that occur while Julie's is driving our vehicle. Mannheim then said, but wait a second, Julie's, you breached the agreement. How did they breach? They didn't have W-2 employees. They didn't provide screening. They didn't provide safety training. That had nothing to do with Patriot, Your Honor. Julie's breached the agreement, and because Julie's breached the agreement, Mannheim then said, we don't have to cover you anymore because you breached the agreement. So there was a lot of things going on in that deck action. So to say Covington would have won is not only because of the auto exclusion, it's because of all these other issues. And remember, Julie's filed a cross claim against Mannheim to say, Mannheim, you breached this agreement. You were supposed to cover us. So they had defenses. She rolled over. At the end of the day, she said, oh, you're going to pay everything? I don't know how much you're going to pay, but you're going to pay it? I'm rolling over. I don't have to defend. So that's why, Your Honor, I know it's, as you put it, here's what happened. There was other issues going on. And what it boils down to is these are Julie's claims Julie, or sorry, JIS was sued in an auto liability lawsuit. Mannheim's theory is that there should have been an auto policy. What would the auto policy cover? It would have covered the auto claims. Julie's has no damages in the auto claim,
Why
no
not?
losses.
Why not?
You're gonna say because she settled in the deck action. So that comes to, is a deck action arising out of? Actually, let me rephrase that. It's not the deck action. It's the breach of contract action.
Why should Mannheim have just said, you know what? I foresee in the future on July 25, I'm gonna be stuck in an appellate court having this discussion here. You know what? We're a big company. Let's just roll the dice. Julie's, you're still involved in the case. Maybe you're gonna get hit with us too, and you're gonna have damage, and then you're out of real money, and then we can come back after and talk about settling it. Because Julie's, you're telling us that we lost the deck action. We're now coming out of pocket to pay these damages. Please go ahead and sue Patriot to recoup for us, and we assign our claim. I mean, there seems to be angst about the fact that the settlement occurred before or that the assignment occurred before the damages were fixed. But why can't, if Mannheim just let the dice roll the dice and Julie stayed in the case and ended up being joint and severally liable for $2 million, would that be the damages that they are now out of pocket possibly because they didn't get the right insurance for Patriot?
It first depends on which one of the actions you're talking about, Your Honor. If you're talking about the deck action or the auto liability action. Deck action is something separate. A auto liability loss.
I was an insurance defense lawyer before.
Yes,
I
okay,
understand exactly what you're talking about.
you're right. So the auto liability insurance carrier wouldn't step into to indemnify for breach of contract claims. And recall, in the breach of contract claim, Your Honors, Mannheim didn't say you breached the contract because you don't have hired non-owned auto insurance. That wasn't the breach of contract claim. In fact, they couldn't say that because in the record, their experts said Mannheim did not require Julie's to have hired non-owned auto insurance. So that wasn't the breach of contract claim. So to your point, Your Honor, if she had stayed into the auto liability lawsuit, if she stayed there and there was a consent judgment against her in the auto liability lawsuit, we'd be having a different conversation.
What would the conversation we would be having?
The conversation we'd be having is, first of all, who has the consent judgment? So if the injured party had the consent judgment, it'd be a different argument because the injured party could say, you should have had an auto liability policy that would cover the injured party because this was an auto claim. That's what the cases kind of say. The case is anytime you look at a covenants agreement or an assignment and consent, it's the injured party that has a consent judgment, not a third party because of breach of contract. That's the disconnect here. And that's where I was scratching my head from the very beginning. The measure of damages that Mannheim wants to hang its hat on is the consent judgment in a breach of contract case. Yet they're saying that Patriot should have procured an auto liability insurance policy to cover an auto lawsuit. It doesn't connect. It just doesn't connect. So that's why at this point, we're saying Julie's didn't suffer any harm. If Julie's had sued Patriot or insurance carrier and said, I want coverage, and the carrier says, what's your harm? Well, I don't have any harm. Zero.
So Julie's has come to Patriot and says, look, we want to be covered for an event that if one of our drivers of a Mannheim vehicle drives the car to the auction and in the process kills somebody, we want to make sure that we are protected and we are insured. Please procure us that insurance. And Patriot says, no problem, we do that every day.
Mhm.
And then they don't do that.
Right.
Why? I guess I'm having the disconnect. And why isn't that then a claim that can be assigned by Julius to Mannheim to pursue against Patriot if Patriot did not do the exact same thing that Julius asked them to do?
Well, first of all, Your Honor, there's nothing in the record that says she actually asked for that. Secondly, Your Honor, the assignment is not the problem. That's not the issue here. I mean, my colleague wants to make a big deal about the assignment. I am not arguing the assignment. They could assign the claim. I'm saying, where is the harm? If your measure of damages is a consent judgment in a breach of contract case, The auto liability policy wouldn't have covered that. It's a question of coverage. So to your point, Your Honor, yes, the claim can be assigned. It's what are we trying to cover? Where's the coverage? We're not.
But I'm saying, so Julie's comes to Patriot saying, if this could happen
Yes.
in the contract, in the arrangement we have with Manheim, we want to make sure that we have insurance for this if one of our employees causes this death, this wrongful death by driving a Manheim vehicle.
Mhm.
Can you give us coverage to provide that?
Mhm.
And Patriot says, yes, we can. And they said, okay, good. Tell us where we send the premium check to.
Right.
And they say, send it to Covington. We've got you the policy, and they're all happy until they're unhappy when an accident happens.
Right.
And they find out that they have no coverage for
Right.
this. And so they're now concerned about that they are now their company's personally exposed. And Manheim comes in and says, we will take care of all of this. You let us fight the fight for you on behalf. We'll fight your fight against Patriot, but we need to resolve the underlying tort action.
Mhm.
That's what seems to be this case is about. I know there's a separate deck action that comes in because
Right.
Covington says, this isn't what you bought, man. That's between you and Patriot there, Julie's. We provided what was asked to be provided, and we're not covering this because it doesn't cover, it's not covered. And so that becomes apparent to everybody.
Yes, Your Honor.
And so Manheim says, boy, we're getting this stuck to us here, and Julie's, you didn't ask the right questions of Patriot, or Patriot gave you the wrong answers.
Mhm.
And now we're on the hook, and we think Patriot should cover this.
Yes, Your Honor. Again, to your point, though, I think it all depends on the damages. The measure of damages is what would have been covered. So if they had a consent judgment in the auto liability case, that's different because you say, okay, Manheim is saying that you needed an auto liability policy. There's a consent judgment in the auto liability case against the injured party. That's different. Coverage, we're talking about coverage. But the measure of damages cannot be the consent judgment in the breach of contract action, because auto liability wouldn't step across to cover that, Your Honor. That's the point I'm trying to make, is that
They just put the wrong case number on the coverage.
no, Your Honor. I believe, to your point, if Warlick had received a consent judgment and Warlick somehow said, okay, so Julie's was the subject of a consent judgment in the Warlick lawsuit, the automobile lawsuit. That's different.
How would Warlick get a consent judgment if they pay it with pre-judgment? If they say, we'll settle the claim without a judgment being in, but just assign any claim.
I think that's what happened with Manheim and Julie's in the breach of contract. They did the assignment and the settlement and then got a consent judgment. Why couldn't they have done something similar? Could have happened in the Warlick litigation.
That's what I'm saying. They used the wrong case number. If I'm not trying to be simplistic.
Right.
About the argument, but that's what I seem to be hearing, saying, the deck action, we have no damages in the deck action. That's why you lose, Manheim. If it was in the tort case, that might be a different topic to be discussed, but we don't have to discuss it because that's not what happened. That sounds like that's your argument.
It's a coverage question. Yes, it's a coverage question. No coverage for the auto liability because damages were zero. And the consent judgment would not have been covered by auto liability policy. That's where we are. And even Manheim's expert did not say that the auto liability policy would cover the consent judgment. Just briefly, I have 4 minutes left. The collusion argument, Your Honors. So the court made the determination that based on the record evidence, there was collusion.
Counsel, who colluded? Who are the two parties that engaged in collusion?
Manheim and Julie's Innovation Services.
So if you just look at Manheim and Julie Innovation Services, it matters not what the ultimate judgment was that we're asking the insurance agent to cover, right? You don't care if it's just Manheim and JIS, then the fact that they may have that Manheim may have negotiated down after 5 years of litigation, the ultimate amount that they're going to come back and ask for payment from Patriot to doesn't matter.
Doesn't matter, yeah.
Isn't that wild?
Well, here's why it's, as you pointed out, it's interesting because when Manheim and JIS entered into this agreement, the amount of the consent judgment was unknown, undetermined. JIS simply said, whatever you agree to, Manheim, that will be the consent judgment.
But under your theory, they could have agreed to $1.
Yes. They could, I mean, at this point, what Julius did is she just said, whatever you agreed to.
Right, but as long as Mannheim paid anything, they'd still be out, even if they negotiated it down to a single dollar.
Because, right, Mannheim's harm is irrelevant. This is Mannheim stepping into the shoes of Julie's Innovation Services.
But if they agreed only to a dollar, they did the ultimate to protect Patriot, who wasn't there. I mean, if the whole theory of this is that we're protecting the party that doesn't get to engage in the lawsuit.
Mhm.
If we don't care about the ultimate amount that it's resolved for, then what's the theory?
The theory, I think, to your point, that goes to the reasonableness of the settlement amount or the consent judgment. That's whether the number was reasonable or not. I'm going to the point of collusion, as in when Julie's says, I don't care what the number is, you decide, Mannheim. It's $1, 2 million, 5 million, I don't care. When they roll over, according to the Sidman case, that's collusion because you're saying, I don't care what the number is. You're not trying to mitigate your harm. You're not trying to raise your defenses. You're saying, I don't care what it is, as long as you don't collect it from me. And that's what happened here.
But Julie's has,
I'm sorry, go ahead.
no.
Let me follow up then, what I asked your opposing counsel. So if your side loses today,
Yes.
do you agree? And I understood your opposing counsel to say basically you can't go back and contest the Patriots now in litigation with Mannheim about this. You don't get to contest the reasonableness of the amount.
No, Your Honor.
So you would go, I mean, it would basically go back and say they're suing you as an assignee. They're
Right.
suing Patriot because you did not procure the correct coverage, for lack of a better term.
Right.
And if the judge finds that that's accurate,
Right.
or assuming that's for my argument, it's a bench trial, the judge finds for Mannheim that they proved that. There's no ability in part of that litigation, round 3 of the litigation, to say, yeah, but 2 million is too high because we never even was able to discuss this or have a chance to mitigate. Do you agree with what Mr. Stein saying that it's a $2 million bill you're looking at?
I believe so. I believe under the law, it's whatever the consent judgment is, that becomes a measure of damages. Now, there are arguments about, is there a cap pursuant to the insurance policy? But again, we're back to coverage. Is there a cap? But I think under the law, if we cannot argue, the only way we can argue reasonableness is to go back to, is this consent judgment enforceable? Because if it's unreasonable, it's not enforceable. So I wasn't, and the underlying action, I wasn't arguing about the reasonableness. I said, put that aside. Let's talk about the collusion that happened here. And what went on when Julie said, I don't care what the number is, as long as you don't collect it from me. In fact, look at the attorney's fees issue as well. She said, whatever your attorney's fees are, I don't care. So Mannheim said the attorney's fees we incurred in the automobile action and the breach of contract action. Julie's, you're on the hook for that. But don't worry, we're going to collect it from Patriot. It just reeks with unfairness and inequities, Your Honors. I think I'm over, right? Is that what you're saying?
Time's up, yes.
Yeah, let me just say, the court did not, the lower court under the new summary judgment standard, looked at the record, understood the issues, applied the law, and made the right decision. The court should affirm. Thank you.
Thank you, counsel. Well,
Thank you, Your Honor. I realize I only have less than 3 minutes. I wanted to quickly make the point because this is an issue that was not only at the lower court level, but also within the briefs. The framing of this dispute, my colleague keeps saying it's a question of coverage. Mannheim is saying they should have procured an auto policy. The fact of the matter is the complaint is much broader than that. The complaint is alleging that Patriot breached its fiduciary duties that it owed to its insurance client, Julie's, alleging that they failed to explain to Julie's what the Covington policy would and would not cover, failing to advise Julie as to the ramifications and the exposures that it would face with a liability policy that excluded from coverage any claim arising out of the automobile, failing to review the staffing agreement that JIS provided to Patriot, which included the indemnification obligations that Julie's owed to Mannheim, and ultimately expressly recommending and not procuring the appropriate liability coverage for a longtime client who was not nearly as experienced as Patriot in the insurance realm.
Let me ask, getting to the last topic we discussed with your opposing counsel, the collusion issue. Basically, he's saying the record is clear. The Julies took the position saying, we don't care what number it is. We don't care the amount of the fees. It doesn't matter. Put any number down, whatever it turns out to be. That's not our concern. Is that not indicia of collusion?
I would submit, Your Honor, here's what happened. Again, when the claims in the coverage lawsuit were settled that accompanied the assignment. Then there was the actual assignment that was executed a few weeks later that had some language, as my colleague correctly points out, did not have any language limiting the amount of damages. But again, Julie's was represented by counsel as it relates to those cross claims, not paid for by Covington, paying out of its own pocket. And ultimately what happened is that the consent judgment, that first consent judgment that was entered later on in November, again, consent meaning that there was an agreement, it imposed that cap that no matter how much, whether the Warlick lawsuit resulted in a trial of $5 million, $10 million, if it's settled for $3, $4, $5 million, that Julie's maximum exposure would be limited to $2 million. And then the fact of the matter is, Your Honor, Mannheim continued to litigate, aggressively defend that case, and ultimately was able to negotiate a settlement that was below, more than 10% below the cap. So we would argue that those facts belie any
So they settle within the amount of the coverage they were required to provide under the staffing.
well below that amount of coverage, Your Honor.
Close, but 1.8 total or something like that.
Right.
Yeah, I agree. 200 grand each.
Counsel, I want to follow up on our conversation that we had before you sat back down, and you had mentioned that defense costs were damages that accrued before the assignment, and then they were later able to app on just because we had that damage sustained before the assignment. Can those attorney's fees, can those defense costs actually be damage if Covington was providing a defense the entire time? Covington was providing a defense under an ROR.
I'm glad you raised that point, because as I was sitting there, it occurred to me as well. One of the impetus of the settlement agreement was that as it relates to the cross claims that Mannheim had brought against Julie's in the coverage lawsuit for breach of the staffing agreement, saying you owed a, so Mannheim was incurring defense costs for at least more than a year. I want to say almost 2 years, litigating the cross claim before everyone had the realization we're wasting money litigating these coverage issues, the deck action, as well as the cross claims, when at the end of the day, we all know that Julie's is going to be left without any liability coverage. So there were attorney's fees relating to the prosecution of the cross claims for breach of contract and contractual indemnity under the staffing agreement. So we would argue that those were damages that accrued the minute that Mannheim was spent litigating those cross claims for breach of the
But this
staffing.
is not the Warlick action.
No.
This is not JIS being left to defend itself in the Warlick action and the tort action.
This is JIS Mannheim having to incur defense costs to prosecute the contractual indemnity claims, and JIS having to incur its own costs without any defense provided by Covington defending those cross claims for breach of contract and contractual indemnity. And with that, I believe my time.
Your time is up.
Thank you, Your Honors.
Okay, good morning. We'll now proceed to our final case on the docket. Jenny Lynn Wagner versus Hartzell Propeller, Inc. We have counsel for the appellate identify himself. Mr. Rosenthal. And for Hartzell Propeller.
Brian Hall.
Okay, Okay, we'll each have 20 minutes. Council, would you like to reserve some time?
Six, knowing my.
Six. Sure. Got it. All right, you are recognized.
Morning, may it please the court, Stephen Rosenthal on behalf of Ginny Link Wagner as personal representative of her husband's estate. I know that a lot of complex issues have been briefed for this case, but I want to try to shrink the focus to something that I think the court only need decide to resolve this appeal. There's a discovery ruling here, which was based on a pure error of law that this court can review and should review de novo, which concerns which contacts by an out-of-state defendant are relevant to the personal jurisdiction analysis. The ruling here was wrong as a matter of law, and it handicapped Wagner from gathering evidence to respond to Hartzell's motion to dismiss for lack of personal jurisdiction. That is the only issue that this court need decide. There is authority from the second DCA in a case that my opponent cited, the Volkswagen versus Jones case, which involved a reversal of a denial of a motion to dismiss for lack of personal jurisdiction, which nonetheless remanded to the trial court because there was a motion for discovery, for personal jurisdiction discovery, that trial court hadn't decided. Here, the trial court limited erroneously the scope of personal jurisdiction discovery, and the result is the same as the VW versus Jones case. So that if this court decides that the discovery limitation basically handicapped the plaintiff from being able to respond to the motion to dismiss, which is what happened here.
Is that because they wanted to look into every model, every aspect of all of their dealings in the state of Florida?
I think the right answer is that the question is, what is the proper scope? And we sought a broader scope than the trial court allowed. And I guess the way you just phrased it, Your Honor, about any dealings is perhaps overbroad. And I think that this court does need to decide what is the proper parameter, both under the long arm statute and the the constitutional prong. But the answer is set forth in a litany of cases, which is the range of products, the line of products that company sells. And why is that? It's mainly because, at least under the constitutional analysis, we're looking at its efforts to exploit a market for those products. So it begs a question of market definition that I don't think this court has wrestled with, or really any DC has necessarily wrestled with. It's more of an antitrust concept, frankly. And even the US Supreme Court doesn't sort of get into great detail about what is the market. It's sort of
Let me ask you, counsel. So basically, there was a limitation on the jurisdictional discovery imposed by the trial court here.
correct.
And you're saying that what the trial court did below was an error as a matter of law.
That's right.
And I look at the third DCA, Estes v. Roden. We further review a denial of a request for jurisdictional discovery for an abuse of discretion, which is a different standard of review we have.
Right.
So are you saying that that's wrong, what they said in the third DCA?
Well,
Or how are you not saying that's wrong?
so it's a different circumstance. I am saying that a different standard of review applies. That's partly why I submitted over the weekend the Supreme Court of Florida's most recent decision on standards of review, because it really broke down the importance of looking at the specific circumstance at issue, and a different standard of review applies depending upon the circumstance. In that case, Estes versus Roden, the reason that the court reviewed that under that trial court's decision under an abuse of discretion standard was because that opinion said that the plaintiff had asked for discovery at the last minute, at the 11th hour. It was a procedurally improper request for discovery. That was the issue that was being reviewed for abuse of discretion. I don't think anybody would contest that a trial court has that kind of discretion. Here, there was a completely proper request for discovery. Discovery was simply propounded early on in response to the motion to dismiss, I think 2 or 3 weeks afterwards. And then when Hartzell objected, citing cases in its response to the request for production, saying this is beyond the scope of what's legally permissible, our side moved to compel. And that's what the trial court ruled on. And so there's no question that it was a pure question of law at the motion to compel phase, which led to the discovery ruling that we're appealing. And I'll just point this out, that plaintiff argued in the motion to compel that defendant's position is, quote, based on a misstatement of law. That's at R 253 and 256. They responded to that with a brief saying, quote, it's actually plaintiff's argument that's based on a misstatement of law. That's at R 294. In other words, he said, she said, but purely about the law. And that's what was argued at the hearing. And the court decided that Hartzell's narrow view is correct, specifically that the only discovery we're allowed to get is the particular model of propeller that was on the accident aircraft. The law says completely differently, that we're entitled to a broader range of discovery, not just that particular model, but anything that was in that product line. What does Hartzell sell?
Wasn't there, I mean, those some affidavits that said, we kind of answered that question anyway, so the trial court, when they made their ruling, had the benefit of an affidavit that addressed their overall contact with Florida.
I missed the beginning of your question, but
Wasn't there an affidavit? I'll look for it. See, it seems that there was an affidavit that kind of addressed a more broad spectrum where the trial court had that, the benefit of them saying.
The executive vice president.
correct, yes, Mr. Brown, in connection with their motion for summary judgment, they did submit, I'm sorry, motion to dismiss, they did submit an affidavit. In that affidavit, though, what I would point out, the most relevant point here is that the affiant spoke of propellers and associated components. That's in effect their own market definition, propellers and associated components. They do say in that affidavit, we only sold this one, to a seaplane base that was in Florida. We sold it in Ohio, but we know
There's
it's not.
another one at some point.
A subsequent affidavit after the U.S. Supreme Court decision in Ford came out said there was another one of this particular model. But I think the point is that the court looked and made us proceed through a tiny aperture, a very, very narrow aperture. As though I'm thinking of like the Ever Ready Bunny commercials. In that commercial, which is advertising by Energizer into a state, let's say hypothetically, if there was a lawsuit about a defective 9-volt battery for Energizer, and then they say, well, look at the commercial. They say, no, but in the commercials, they take a C cell out of the bunny, and that's a C battery, not a 9-volt battery. You can only look at 9-volt battery sales. That's effectively what the court did in this case. But obviously, batteries are the market for which that Energizer advertising is going to. By the same token, we were saying we're entitled to see what kind of advertising Hartzell does for its propellers for aircraft. That's the same market. There really isn't a dispute. And I searched the papers. I don't think that there's a dispute about what the appropriate market is. And that's the key language for the constitutional due process analysis from Volkswagen, worldwide Volkswagen, through the most recent Ford decision. There are decisions from this court. I know Judge Stargell, you wrote the Robinson helicopter case, which I don't think that issue was framed, but the language in that case that Your Honor used was systematically served a market in Florida for the type of helicopter involved in this case. Now, the type of helicopter means it's a helicopter. If there's a completely different type, and I don't think this language was designed, to the specific issue, then that may be a different market. The U.S. Supreme Court has always said you serve a market for the product, and it speaks in terms of automobiles. In Ford, it was Ford automobiles. In Volkswagen, it was Volkswagen Audi automobiles, not a particular one. In the third DCA's case, which I submitted in our reply brief because it had just come out, Mazda Motors versus Trish, it was a Mazda 3 sport vehicle that was at issue. The court looked at all of Mazda's vehicles sent into the forum and its advertising and contact related to that. So backing up, the problem we face in this case is that the trial court forced us through the eye of a needle, and the discovery only revealed a small fraction of Hartzell's contact with the state of Florida. That is reversible error. It is a purely legal issue, Judge Lambert. It should be reviewed de novo, both under the general proposition that's well established in this state, that if an issue of law is decided, that's not an abuse of discretion. This is the Canicaris case from the Supreme Court from long ago. It's an application of the wrong legal standard. So it should be a de novo.
Would you lose if it was the abuse of discretion standard?
No, I don't think we would.
Why not?
Well, because I think it's so clearly a departure from what the proper application of the facts are to law. I don't even see, though, the factual application. I mean, there really wasn't just a dispute about any facts. It's a question of which of our products, which of our contexts about our products are pertinent for discovery. Didn't really require a factual analysis. It's just a question of how broadly do you draw the circle. And frankly, Judge Lambert, if it was an abuse of discretion standard, I think you would have to look at the most recent decision from the Florida Supreme Court in Al-Ahad that I submitted in supplemental authority, which just says, look, if maybe it's a mixed question of law and fact, and depending upon the questions the court has to ask to get to the right answer, is this more of a legal question? Are we better situated than a trial court or equally situated to a trial court to address the particular question? That governs the standard of review. So there's no question here that the trial court was led into error on this scope of review issue, on this scope of discovery issue. Because the defendant, Hartzell, and its co-defendant, Avco at the time, argued that the narrowest aperture should apply, which is only but for causation, any context that actually gave rise to the claim. And that claim, that argument, was wrong at the time. And I think it's important for this court to recognize at the time that discovery was being sought, the motion to dismiss for lack of jurisdiction contested every aspect, every prong of the analysis, even the long arm statute. And so it does turn out to be that the court ultimately decided the motion to dismiss 6 or 8 months later on the constitutional prong. And there's a debate about how you can read that order, whether it's just relatedness or whether it's all of minimum contacts, and it's an unclearly written order. But I don't think the court has to even get to that point. The main point is that if you back up in time, at the time that the discovery ruling was made, they were contesting the long arm statute too. And this is, to me, the clearest point for the court to take cognizance of. For 40 years before that ruling on discovery, this courts in Florida had taken the position and established that under the stream of commerce portion of the long arm statute, 48-193, what became 1A 6B, which is the one that plaintiff ultimately proceeded through and was at issue at that hearing as well. The court said that the contacts that are implicated are the entire quote product line of the defendant. That's the Davis versus Pyrofax gas case from 1986, the Florida Supreme Court. And perhaps the most explicit statement in all of Florida jurisprudence on this whole issue is the Shohei safety helmet case from the 4th DCA in 1981, which I think the Davis Supreme Court case referenced. And they said, quote, the case boils down to whether there must be connexity, speaking to the long arm statute, to the specific manufactured object involved in the cause of action, here the specific helmet worn by the injured appellee, or whether the connexity can be to the general manufacturing activity in which the non-resident is engaged. Here, all models of of motorcycle helmets. We find the latter more persuasive. So based purely upon Florida law relating to the scope of the long arm statute and what discovery you're entitled to, the trial court was wrong as a matter of law. But it was also wrong as a matter of law on the constitutional prongs, because under even just the relatedness prong, as I've already mentioned, the test looks at serving the market for the product. So there's an obligation upon a defendant resisting discovery to say, wait a second, the market for our product is very, very narrow. That was never said in this case. Under the worldwide Volkswagen case, which was on the books in the 1980s, long before the discovery ruling, the court said, quote, the sale of a product is not simply an isolated occurrence, but arises from the efforts of the manufacturer or distributor to serve the market for its product. So the question is, what are efforts to serve the market for the product? Here, the product is an airplane propeller. Happens to be a particular type of airplane propeller, happens to be for a seaplane. Maybe that's different from other propellers. That's not even part of the record in this case. It wasn't a part of the record they made in opposition to the motion to compel broader discovery. We submit that the market, it's uncontested, is airplane propellers. Those consist of an assembly and blades, according to their affidavit. Fine. We requested lots of discoveries seeking all of their contact with Florida, advertisements, sales, dealings with third-party distributors. They're not distributors, actually. They're 2 different shops in Florida. They're independent, but they have a relationship with them. Tell us about that with respect to all propellers. And they said, well, no, we're just going to give you, and the trial court allowed them only to get information about this one particular model of propeller. Very, very narrow. It's like the 9-volt battery example.
So what information was received in that narrow scope?
2 sales of that particular kind of propeller in 20 years, And it's not contested that there are various trade shows in Florida. There's an issue about whether or not that was sufficiently proposed evidence because no affidavit was filed by the plaintiff, but it was uncontested and it was never raised as a defect evidentially. But the bottom line is that we are looking at a very incomplete record. And so what this court ought to do following the VW versus Jones case, and I see I'm at the end of my rebuttal time, is allow a proper discovery of jurisdictional facts to happen, and then allow a reevaluation of the jurisdictional defense with all the facts on the table.
What is the sworn evidence from the plaintiff in opposition to the defendant's motion to dismiss?
There is none. It is solely a failure by the defense to contest the evidence the plaintiff put in that it had to go scrapping for because the trial court limited the kind of discovery that it could get, other than the reference to the interrogatory response and final defense. But again, all of those would collapse down to this very, very narrow focal point, which we had no chance on. And so we're saying the court needs to expand that focal point in order for us to be given a fair opportunity to respond to that motion. I'll reserve this time.
Yeah, a little over 4 minutes. Counsel, you're recognized.
Good morning. May it please the court. I'm Brian Hall on behalf of the appellee Hartzell Propeller Inc. I think some interesting and weighty constitutional questions surrounding what types of contacts should be considered have been raised here. And in the wake of forward courts across the country have examined that question and come out in different directions. But this is not the right case for the 6th District to decide these significant and far-reaching issues about what contacts should be considered, because this is a case that can and should be decided on much simpler grounds. The first is that Wagner did not challenge the sole ground that the trial court decided when it dismissed the case for lack of jurisdiction. And the second is Wagner's challenges to the discovery order cannot affect the outcome of the case. The final order dismissing the case for lack of jurisdiction was not properly challenged and must be affirmed regardless of what may have happened in this earlier discovery order. And so I'll touch on those issues first, and then I'll dive into why the trial court did not abuse its discretion in narrowing discovery, and then why the trial court correctly decided that it lacked personal jurisdiction over Hartzell.
So you don't think this is an issue of law? It needs to be the limitation of discovery.
No, I do not. I think it's an abuse of discretion standard that should be applied. I think that the issue there is, did the trial court abuse its discretion when it narrowed the scope of discovery for that jurisdictional discovery? Standard of review for a discovery order is always abuse of discretion. Jurisdictional discovery in the case that you pointed to also is abuse of discretion. And here in this case, the parties objected on several grounds. Hartzell and the co-defendant Avco. They objected not just on the ground of legal relevance, but also to the vast overbreadth of the requests. And both Hartzell and Avco pointed to the Glen Eagle case, where the Florida Supreme Court said that jurisdictional discovery must be limited, that it should not be broad or onerous or expansive, and where possible should be carried out to minimize the expense to the defendant. So this necessarily means that a plaintiff is not going to get all the relevant discovery that they may be asking for, all the discovery that might be relevant in a legal sense. I think Glen Eagle requires the trial court to put limitations on jurisdictional discovery, even if it means the plaintiff doesn't get everything they're looking for. And so I think the question here is not whether the trial court just found that this information was relevant to the jurisdictional inquiry. The question is whether the trial court abused its discretion in setting these limits on jurisdictional discovery. And I think one way to look at this is like a Venn diagram. You have the circle of contacts that are relevant or that are related to the cause of action. And then you have the circle of the contacts that show purposeful availment. And really what's relevant to the jurisdictional inquiry is where those circles overlap in the center of it. And what the trial court did here was the trial court went right to the center. We'll give you, plaintiff, the contacts that your case arises out of or relates to. And it might have been a different thing if this was an issue of general jurisdiction, and that's not what had been raised here. This was specific jurisdiction. So the trial court properly circumscribed the scope of discovery to what was really going to matter here, to what issues the parties said they were raising in the motion to dismiss for lack of jurisdiction. And I think what the trial court did was fully consistent with Glenn Eagle's requirement that jurisdictional discovery must be limited. Otherwise, they would be entitled to all contacts like they were looking for. And Glenn Eagle said there has to be some limits on this. I want to back up though and talk about the basis for the ruling on the motion to dismiss for lack of personal jurisdiction, because there was some question that was raised about what was actually decided. And I think the best place to look is the Ford opinion. And as we've mentioned, that came out just before this hearing. The parties had thoroughly argued Ford, and Ford clearly decided the case based on the arising out of or related to prong. And I'd like to read to you from the second to last sentence in that opinion and how the majority resolved the related to or arising out of prong. They said, for all the reasons we have given, the connection between the plaintiff's claims and Ford's activities in those states, or otherwise said, the relationship among the defendant, the form of litigation, is close enough to support specific jurisdiction. In our case, the trial court borrowed those exact words in her order. She says, the court finds that the connection between the plaintiff's claims in the amended complaint and the activities of defendant Hartzell Propeller Inc. are insufficient to support jurisdiction. Trial court decided it based on the same prong. She just came out differently than the Ford case had. And so in Wagner's initial brief, all she argued was that the trial court got the purposeful availment decision wrong. The actual basis of the trial court's decision was never even challenged. And they put forward an alternative interpretation of that order, which is that it decided the entire constitutional prong. Well, if that was the case, the entire constitutional prong is decided based on three different parts: arising out of or related to, purposeful availment, and fairness. And so the trial court's order could have been based on any of those three prongs and could stand on any of those three prongs, which means in order to challenge it on appeal, they had to show each of those three prongs, and they didn't do that. All they focused on was purposeful availment. So even taking the alternative interpretation they've advanced, it still brings us back to the original point that we raised in our answer brief. They had to show why the trial court erred in deciding the claims were not sufficiently related or sufficiently connected to the Florida contacts of Hartzell, and that's something Wagner never did. So as I was mentioning earlier, that means the final dismissal order has not been properly challenged and should be affirmed. And so we don't even get to look at this interlocutory discovery order. It can't change the outcome if the final order of dismissal has to be affirmed. But even if you do look at the discovery order, Wagner argued that she needed this broader discovery to show purposeful availment or fairness.
Let me ask you, this
Sure.
big picture, there's nothing that precludes Mrs. Wagner from suing you guys in Ohio, where you all are, right?
No, there's nothing that isn't. In fact, she has. That lawsuit is pending but has been stayed.
Okay.
And so I would also say that to the extent they've now argued that Ford allowed this broader scope of discovery on whether claims arise out of or related to these Florida contacts, they waived that. They specifically told the trial court that Ford allows broader discovery, but we don't want to delay this hearing. We want to move forward with what we have. So they had the opportunity to go back and get this broader discovery after Ford, and they didn't take it. So I think I'd like to touch on the issue of how broad the contacts should be, and whether in the trial court, when she put these limits on discovery, when she narrowly tailored this discovery, she did it by focusing on the model at issue. And she allowed Wagner to take whatever discovery she needed on the same model of Propeller here. And I would submit that this limitation was well within the trial court's discretion. And that's a point that I would say was later confirmed by Ford when they intensely focused on the model of the product at issue. They talked about all sorts of contacts, and every time they came back to that included these very vehicles at issue here, that included these same models. And Ford said that, or in the opinion of Ford, Justice Kagan says that Ford systematically served the market in Montana and in Minnesota for the very vehicles that plaintiff alleged malfunction. And the second district's Robinson opinion that Judge Stargell authored said the same thing, that Robinson Helicopter did not systematically serve the market in Florida for this type of helicopter.
So you thought that was a pretty good opinion, Robin?
I think it's very applicable to our situation here. Yes.
Well written, Robin?
I think it was. I think it's an important distinction to make, though, because this collection of general or generic contacts doesn't suffice unless you have contacts that relate to the same product model. And as an example, a product that a company decides might be suitable for the Florida market may not be suitable for a market, say, up in Alaska. As an example, the manufacturer of Sea-Doo watercraft also makes snowmobiles. And if somebody brings a snowmobile down here to Florida and gets hurt, they can't rely on the company's Florida contacts with respect to Sea-Doo to show that, to sue here for injury on a snowmobile when the company never serves the Florida market for that product. I'd like to look to, or I would say we look at the Volkswagen case and the Ford case, which both say that defendants can structure their primary conduct with some assurance where that conduct is going to render them liable to sue. And that means that companies can choose which markets to serve with the particular model, or which markets they don't want to serve with that model, or whether they're not going to market a model at all, like a rare or unique product that the company just chooses it's not going to sell in stores anywhere. It's been said that the market here was propellers, and that's not our position. Our position is that it's the model of propeller. Did Hartzell serve a market in Florida for this specific model of propeller? And so if you look at Ford, where they talked about Crown Victorias and Explorers, I think we all know the difference between, say, a Ford Explorer and a Ford Ranger, or a Crown Victoria and a Bronco. And propellers come in very different models as well. They come in different sizes, different shapes, different numbers of blades, materials, components, and they're built for certain airplanes and certain engines. They have certain purposes. Some are suitable for backcountry flying or Alaska bush flying. Some are better for speed or aerobatics. Others are suitable for commercial and passenger aircraft. And as has been mentioned in this case, this was a model used on a seaplane. And so what I would submit is that contacts for one model cannot show that the company makes a market for a different model that is not sold in Florida. And the affidavit that we submitted here, as was pointed out, show that this propeller was only sold twice in 20 years to a customer that resided in Florida. And that sale took place up in Ohio, and the customer took possession in Ohio.
But counsel, when we say the sale took place in Ohio, that's only by the application of the UCC, correct? I mean, to a regular person, if you order a product and the product is shipped to you, you may not conversely say, well, that sale took place in Ohio, that sale came to your door. But when it comes to the model, I want to get back to the model. Why wouldn't it be fair to say all propellers on seaplanes? Because the model is as narrow as you choose to make it as the manufacturer, correct? I mean, you could choose to say something is different for a whole host of reasons that may not have practical effect.
If the argument was, for example, all models for seaplanes, that wasn't the discovery that they asked for in this case. They didn't take discovery on seaplane models. They didn't ask the trial court to compel discovery on seaplane models. They asked for everything. And we said it should be we said it should be actually the individual propeller that was there in the trial court, looked at all of this and said, I'm going to give you everything with respect to that model. So it was never argued and never challenged that it should be anything other than every Florida contact that you have. And so they didn't take a deposition on jurisdiction where they could have asked those sorts of questions. They did serve jurisdictional interrogatories. Those were never submitted in response to the motion. They never submitted any request for admission responses along with their response to the motion. So could they have asked for that? Perhaps, but that's not what happened. And so the trial court was never able to pass on that issue of whether or not the market should be considered, say, seaplane propellers, for example. I did want to touch on the Mazda case. Because that came out recently. In that case, I do want to point out that the specific vehicle at issue there was sold in Florida. So we have a completely different situation than here. The court there also pointed out that Mazda Japan had ordered recalls of the make and model of the car at issue. specifically naming Florida, that Mazda Japan developed lines of vehicles, including the subject vehicle for the US market. So that case had clear Florida contacts involving the specific model at issue. And so in that case, there was no need for the third DCA to separate out the models in that case, because that clearly involved the model of the vehicle. There was no need in Mazda to decide the question then that Ford had left open about models that are not marketed in the forum state. And that is the issue that we have in this case, where a model was not marketed and was not sold in Florida. And while it was sold to Florida customers who took possession up in Ohio twice in 20 years, that's the truly isolated and sporadic type of sales that the opinions of the US Supreme Court have referred to. On the motion to dismiss order, the order dismissing the case for lack of jurisdiction, the trial court got it absolutely right. The record failed to show the required connection between any forum activity of Hartzell Propeller and this claim. We had submitted 2 affidavits that Judge Sargel had mentioned. The first had a very long list showing the lack of any Florida contacts, including the sale for these propellers. And then after Ford, we submitted another affidavit that said again, this model was only sold, twice in 20 years. And so this case, as I mentioned, is exactly the case that Ford said it was not addressing, where a model is not marketed and sold in the state. And the response to that motion from the plaintiff was to attach just a few documents that were not sworn, and that we would submit the trial court never considered. She, in her order, listed out what she was considering, and that was not included there. And so I would say that that she was following the Florida Supreme Court's instruction to only consider sworn materials, and that's a point that we had made in our motion, and we had made in our supplemental briefing as well. And so, but I would say that even if the trial court had considered those materials, it doesn't change the outcome on the jurisdictional inquiry. All they pointed to was the existence of independent service centers or potential appearances at trade shows. And there's several problems with that. With the independent service centers, again, they're independent entities, not owned by Hartzell, not controlled by Hartzell. And I would point to, of course, the Robinson case, which found that that's not sufficient. And I'd also point to the LNS Enterprise case from the Ninth Circuit that we mentioned in our brief that says the same thing. With respect to the Ford versus Atwood vacuum case, that also does not change the outcome with respect to independent service centers. And that case involved component parts that were sold outside Florida, incorporated into a product that was then sold within Florida. And that was clearly connected with a claim. The product was sold here in Florida. So that case was really a purposeful availment case, not a case of whether the product was connected to the contacts. And I would also submit that it's not consistent with later cases out of the United States Supreme Court, such as Asahi and the cases that followed.
You got about 3 minutes left. We'll go back to your waiver argument for a moment. Your suggestion was that the court offered to the plaintiffs the opportunity in a hearing that you all had. Is that correct?
It was a discovery hearing. I know, I apologize. Actually, it was the hearing on the motion to dismiss for lack of personal jurisdiction. And Wagner brings up that after Ford came out, perhaps Ford allowed us to take this broader discovery. But we're ready to move forward with what we have. We don't want to delay the hearing. And so that opportunity that she may have had to seek greater discovery under Ford, she said she didn't want it.
They realized that they might have had that opportunity had they filed a motion and asked for it below, but they didn't do it. So you're arguing that's the waiver, that they had knowledge and failed to apply.
After the Ford opinion came out, yeah, to the extent now that they're saying that Ford allowed this broader discovery, well, they waived that when they got to the.
And acknowledged it in open court.
Yes, yes. With returning to the independent service centers, again, any contacts with respect to those would have to relate to the cause of action, and there's no evidence whatsoever of that No evidence that the independent service centers ever serviced this particular propeller, or even this model of propeller. And then with respect to the trade shows, at the most, all that showed was that Hartzell attended air shows in Florida. There was no evidence that this model of propeller was ever presented or used at those air shows. No evidence that it was exhibited or taken to displayed in any way. So again, I would emphasize that they were allowed discovery on whatever evidence they needed on this model. And they didn't present any evidence of any Florida contacts with respect to this model. And generalized contacts without evidence that involved the model at issue can't rebut the affidavits that we submitted showing there were no contacts with respect to this particular model. So I would submit that the trial court acted within its discretion in placing very appropriate limits on jurisdictional discovery, consistent with the Florida Supreme Court's opinion in Glen Eagle. The trial court correctly held that there was no relationship between any Florida contacts of Hartzell and Wagner's claims. But as I mentioned before, these are not even issues that the court has to reach because they haven't been properly presented here. The constitutional questions that the briefing had raised are interesting, they're far-reaching, but this isn't the right case to decide those. The trial court's order should be affirmed.
Thanks, counsel. Right, 4 minutes remaining.
I'd like to begin with the question that Your Honor, Judge Startle asked
About the waiver?
counsel, yes, opposing counsel, which is that you said, Your Honor, that was there an opportunity that the trial court offered the parties to expand discovery in light of the United States Supreme Court's decision? And I may have misheard the response, but the answer is clearly no. And if you look at the record, when this came up, the only time it came up was on the second to last page of the hearing transcript of the motion to dismiss hearing. My colleague, Ray, who was trial counsel, volunteered that, look, we're handicapped because of the limited discovery you've given us. And I'm specifically referring to pages 707 to 708 of the record. And, had Ford come out earlier, maybe this would have been different. But, we still think you should win and you should just deny the motion to dismiss. That's the context in which it came up. It was not an offer from the trial court to revisit things. This was a last minute at the very end of the fully briefed, long special set hearing.
That's what I was asking, because I heard him at first that I didn't see that in the briefing, but it seems what his argument is now is that statement shows that there's knowledge. Ford might have been a game changer. Why didn't you go back and, even though you had been denied earlier, come back and have it assessed under Ford?
I don't actually think Ford was a game changer in that respect. I mean, certainly it crystallized the issue much clearer than it had been before. But even prior, I think, okay, so let me just get the
A lot of
timing.
people that famous Spark thought it was a big game changer, but
It's an important decision, no question. But I guess for the relevant point here, so the hearing on the motion to compel broader discovery was on February 8th, 2021. I'm sorry, that was the date of the order. The hearing was a little bit earlier, it was in January. So on February 8th, the trial judge issues her ruling restricting discovery very narrowly. The Ford decision came out, and she had ordered us to reserve the discovery in a narrowed fashion, which we did on March 1st. Okay. The Ford decision came out on March 25th. Actually, and Hartzell had already responded to that narrow discovery on March 22nd. Hypothetically, I agree. One could have then said, wait, there's a new decision out. Let's move for reconsideration. The trial judge has already ruled against us. And the reason I say that you shouldn't put so much weight on that is that we had already argued to the trial judge that other law said, Davis versus Pyrofax and Shohei and Worldwide Volkswagen, which basically the Ford court just adopted. It was dictum in the Worldwide Volkswagen case about contacts to exploit the market for the product. Ford said, yeah, now that's the holding of the court. And there's a debate on the language of that opinion as to whether or not it was talking about a narrower market definition or a broader market definition for the product. That case really didn't delve into and try to answer that question. But the point I'm making is that the decision had already been made we had already made all these arguments. So Ford really wouldn't have changed that. So I don't think the court can put too much stock in the fact that a decision was not made to seek reconsideration. And it would be definitely unfair to the plaintiff to say, because you mentioned it at the very end of a hearing on the substantive motion, that boy, I wish things had been different. You had already ruled against this, judge. That's not something that we should be afraid of. Let me, in the very little time I have left, respond to two other points. Note that the Ford decision, US Supreme Court, talks about the quote unquote auto market, which is broad. And the differences that my opposing counsel raises about there's different kinds of propellers, some are seaplanes, backcountry flying, all that. None of that's in the record. I don't fault him. My point is to say that if a defendant wants to try to narrow the scope of the market for purposes of jurisdictional discovery at a personal jurisdictional discovery phase, it should do that. The only thing it did in this case was say, we sell propellers. Okay, so that was essentially the going definition of the market at issue, propellers. That's what they make. And so maybe in the future, cases will be more like the Alvarez case, which is, and I see I've gone over, I'll try to wrap up, which was the other case for standard of review that they cite. But Alvarez was not a personal jurisdiction discovery case. It was just about tires and discovery for the merits. And you look at other similar incidents evidence. There's a lot of law on OSI, as I call it, evidence. And trial courts have to hold evidentiary hearings with experts dueling about which products are sufficiently similar to one another for purposes of discovery. Perhaps that's the kind of thing that has to happen if we're defining markets more particularly at the jurisdictional discovery phase. But that didn't happen in this case. They said, we make propellers. We said, give us your contacts for propellers in Florida. We want to know how you serve this market. And the trial court denied us that. So there was no waiver here. There was no effort by them to narrow the market. We were entitled to the appropriate market. So respectfully, I would submit that following the Volkswagen versus Jones case from the second DCA, which for what it's worth is 227 Southern 3rd 150, this court ought to decide a simple narrow issue, which is that this, as a matter of law, the jurisdictional discovery was too narrow in this case. The plaintiffs should have been entitled to broader discovery about what the out-of-state defendants' contacts were to exploit the market for propellers in Florida. And assuming, which you don't even need to decide, that the motion to dismiss was properly granted, we still say under VW versus Jones, paraphrasing language I would like to see, that the court should reconsider this with the appropriate discovery granted and then determine the motion to dismiss. For those reasons, we believe the court should reverse on that limited ground.
Thank you, counsel. Very well argued on both sides. Thank you for your time today. And with that, we stand adjourned.